And again, to what extent service providers may exercise or assert certain rights over the data that you place within a cloud environment. Facebook, I know not a corporate example, but certainly something that is close to many people's hearts, is an example where they assert rights to utilize content that you put on the site for purposes that may be above and beyond those that you expect as a user. And in a cloud environment, as in the internet in general, the challenge is often that our awareness or knowledge of intellectual property is inevitably bound by our recognition of national law. And in a cloud environment, transnational, the holding of data in other jurisdictions may mean that we are not able to assert rights that we would were that data to be found in the UK. In terms of data protection, Graham talked about the fact that the Data Protection Directive is under review, and it's been recognised that cloud computing as one of a range of emerging services does challenge existing data protection law, the distinction between a data controller, a data processor, and data subjects. It challenges exceptions to data protection law in respect of purely household and personal activities. When I put data in LinkedIn, for example, or I put it on Facebook, is one simply a business activity and the other a purely personal activity? Certainly as a university, we're increasingly using Facebook and other social networking media as a way to keep in touch with our alumni. We're using Twitter as a mechanism for alerting our students. All of those raise challenges in respect of to what extent we are the data controller in respect of the personal data placed on the site, or our individual students, or more particularly our alumni, are data controllers and data subjects. And this clearly has contractual implications. You will all be aware that where you are utilizing others for the processing of your personal data, data protection law imposes particular requirements that impact on the contractual relationship that operates between you as the data controller and the processor as the processor of your data. Other issues that arise within a cloud environment are clearly questions of applicable law. And that comes down to my last question, really, is can you actually control where your personal data is stored? From the research we've carried out, some providers can't technically tell you where they are keeping your data. Some companies, like Google, for commercial reasons, will refuse to tell you the location of where your data is being held, whereas other companies have actually recognized that data location can be a business advantage, and companies like Amazon, for example, actually give you, if you are procuring cloud services from them, the ability to choose to have an American cloud or a European cloud, which, as you can imagine from data protection perspective, may offer certain commercial advantages. Moving from data protection, clearly we have these obligations to secure our personal data. And again, within a cloud environment, this gives rise to issues not only in terms of to what extent is the service provider offering you security, but also to what extent are you maintaining control of the security of your data wherever that data may be located. If I put data into the cloud, and it's located wherever it is in the world, but I encrypt it, and I use an encryption methodology and key set that enables me to control it and nobody else, then I wouldn't necessarily have any problems in complying with European data protection law, wherever the data is held, because I am maintaining adequate or appropriate technical and organizational measures. But again, cloud computing is an emerging service sector, and we're seeing within the standard terms and conditions offered by service providers fairly scary standard terms of business which need to be brought to the attention of any organization that is hoping to utilize cloud computing as part of its ICT infrastructure. The service provider has minimal or even no liability for the loss or damage caused by the failure of the cloud computing service. You move to a dependency on cloud computing, the terms and conditions say outages will not give rise to any liability, or in our experience, the primary remedy given to you is future service credits. Obviously incredibly valuable to you if you don't want to use the service again because you hate it and it's never done anything useful for you. However, as with many services within the IT sector, unfortunately the lesson is the more you pay for the service, the more liability the service provider will have in terms of service level agreements and commitments to secure and protect and ensure that business continuity is protected for you from a governance perspective. Other standard clauses which we've come across is the service may be modified or discontinued without cause, without notice, and without liability. We thought we'd try a bit of a cloud service, didn't like it much, thought we'd turn our attention elsewhere. And in certain cases, some responsible service providers will retain your data for a period to give you the chance to shift from one platform to another. In other circumstances, service providers say as soon as you or we terminate the service, your data is no longer accessible. Data retention. Clearly, we have a range of obligations to retain data, both, again, documents themselves, the stuff we write, the stuff we generate, as well as the metadata, the records of the events of when we sent communications, when we received communications, when things took place. We have to retain these things for a range of regulatory reasons, and clearly within a cloud environment, that gives rise to questions about trying to ensure that we comply with, a common retention policy within the jurisdictions in which we're operating. And essentially, our experience, of course, is that one size doesn't fit all. There is not a single set of data retention obligations within the United Kingdom, let alone within a European environment or globally. So organisations have to engage in a risk analysis and they have to make sure that their service providers match that risk analysis through the guarantees of service that they offer. Finally, in terms of law enforcement issues, unfortunately, things go wrong, and for a range of reasons, either requests may be made of you for data by law enforcement, both nationally and on an international basis, as well as you as law enforcement in certain or exercising law enforcement functions in certain cases, may want to get access to data that is residing on computing resources in another jurisdiction. And that gives rise to questions of jurisdiction. To what extent, if you're a domestic law enforcement authority, you have the right to obtain data that is residing in cloud resources in other jurisdictions? Or to what extent you have an obligation when based here to respond to requests from law enforcement agencies operating in other jurisdictions? So in terms of concluding remarks, governance in the cloud, I think, or we think, is an evolution of knowing your data, and more particularly at this stage in the evolution of the market, it's much more about knowing your service provider. Knowing that your service provider can guarantee the levels of service and reflect your needs in terms of governance of data. Understanding how laws apply is always a new challenge whenever you shift from one environment to another, but in this field, as we are aware, governance is as much to do with the attitudes of particular regulators, like the Information Commissioner, as it is to do with the application of statute and regulations. So speaking to and entering into dialogue with regulators forms part of a governance strategy. And finally, to what extent are we seeing law as a barrier to market developments? Cloud computing does offer very tangible benefits in terms of improving the efficiency of an organisation's ICT structure. But if law actually prevents us to take advantage of those efficiencies, then perhaps we need to look to law reform. Government will have to look to law reform. As you know, many of you have been involved in the debates about data sharing. Cloud computing is just another manifestation of that ongoing debate about where the data is and who gains access to it. And with that, I have 14, 13, 12, 10. I've finished. Thank you very much indeed.